Hello, my name is Susan Miranda. I'm an associate at Michael Lynch Family Lawyers, and I want to talk to you today about de facto relationships. You might be asking yourself, I wonder if my relationship would be considered a de facto relationship. A person is in a de facto relationship with another person if they're not legally married to each other, they are not related by family, and having regard to all of the circumstances of their relationship, they have a relationship as a couple living together on a genuine domestic basis. Now, the factors the court will look at to see if two people have been living together on a genuine domestic basis include the length of the relationship, i.e. it has to be usually at least 2 years in duration, or the nature and extent of their common residence, whether a sexual relationship exists, the degree of financial dependence and interdependence, and any arrangements for financial support between them, the ownership, use and acquisition of any property, the degree of a mutual commitment to a shared life, the care and support of any children, and the reputation and public aspects of their relationship. Remember, a de facto relationship can exist even if one of the parties is legally married to someone else or is in another de facto relationship. Also, if you have registered with a state agency as being in a de facto relationship, you cannot later deny that you were in a de facto relationship for the purposes of property settlement under the Family Law Act. Also remember that the limitation period for commencing proceedings for property settlement in relation to de facto relationships is 2 years from the date of separation. Beware of getting advice from family and friends who may think they've been through something similar to you. Every case is unique. I suggest that if you're wondering about your own particular set of circumstances, that you make an appointment to come in and speak to us for an initial consultation.